Hi, everybody. This is Advocate Lucinda, your empowerment lawyer. Today, we are going to talk about personal emails and when they may or may not be privileged. Also, I'm going to share with you some tips on keeping emails private. So let's get started. Did you know that personal emails are discoverable under the federal rules of civil procedure? They are considered electronically stored information under federal rules of civil procedures 34A1A. Please read that rule. Personal emails are discoverable so long as they meet the relevance and proportionality requirements of Federal Rules of Civil Procedure 26B. Now, please read that rule, but I want to point out two things that's included in that rule. First, the section deals with the scope of discovery and the limitations. And also, it addresses claims of privilege or protection of trial preparation materials. So please get familiarized with this rule. Now, if the defendant propound discovery to the plaintiff, the defendant is entitled to any matters relevant to the claim or defense of any party, including the existence, description, nature, custody, condition, and location of any books, documents, or other tangible things, and the identity and location of persons having knowledge of any discoverable material. If it's relevant, the defendant is entitled to it. If it's privileged, the defendant is not entitled to it.
You can't touch this. You can't touch this.
Privilege protects the disclosure of attorney client communications and the attorney client work product. Work product include documents prepared in anticipation of litigation. I recommend you read Federal Rules of Civil Procedures 26B, both subsections 3 and 5. They will give you a clear understanding of the attorney client work product. So let's look at how privilege works. Well, first, you have an individual who seeks the legal advice of a lawyer or a professional legal advisor in his or her capacity. In other words, the person seeking the legal advice and the attorney providing the advice must be done under the umbrella of giving legal assistance. And the communications must be related to that purpose. It must be made in confidence by the client. Now, let me say this about the client. The client is not necessarily limited to the individual seeking the advice formally hiring the attorney. In other words, the individual seeking advice, as long as it meets the criteria that we just discussed, and both the attorney and the individual agree to what they've discussed as being privileged information, instantly a protected communication has been established. It cannot be disclosed by the client or the attorney except where the client waives the privilege. I'd like you to read John Henry Wigmore's Evidence in Trials at Common Law. It will give you a clear understanding further of how privilege works. Now, let me give you the good part. Well, all of it is good, but this is really going to be helpful to you. Tips on keeping emails private. Plaintiff sending personal emails to the attorney or your attorney who you've hired on a work provided email may not be privileged. Thus, the safest way to protect the confidentiality of your emails is to use your personal email address and your personal computer or device. Andrew Milich is a blogger and he provides advice or tips on keeping the emails private. He recommends using an end-to-end encrypted communication products, such as a privacy-first messenger, an email service. Sending emails on a work-provided email may not be privileged, and we need to stress that. When using these products, no technology provider has access to your communications, only you. And this ensures that your confidential emails remain private during a legal process. And he recommends 3 products: Signal, WhatsApp, and iMessage. And I will leave a link of his blog where you can read it and even contact him if you need to. Mr. Milik also recommends using an end-to-end encrypted email products, such as a privacy first messenger and email service. And he says sending emails to the attorney on a work product email may not be privileged. He gives the same warning. He also recommends 3 encrypted email services: Skiff, Tutanota, and Proton Mail. He also recommends to keep track of communications or use ephemeral messages. It ensures that the emails expire after a particular period. For example, Signal Messenger offers disappearing messages that expire after a certain period of time, from minutes to weeks. Skiff offers documents that expire after a period of time. Valuable information. Check it out. I trust this has been helpful to you. And until next time, I'm Advocate Lucinda, your empowerment lawyer.